I try to answer this one as brief as possible. Of course, academic views and neutrals. When we talk about OCMs, of course, OCMs is defined under Section 9 of SDA as a sports body, as the first one. And of course, as sports body, you are then subject to Section 23. Okay, to have your internal procedures. Then, okay, when we talk about internal procedures, of course, you come up with your own constitution, talking about the rules, the way how you solve the problem. Then, okay, Section 38 comes in on what to do with regards to procedures of internal regulations. Then, okay, I believe that again, OCM, for example, the way how I look at, of course, okay, is towards global international sports law. Whereas, okay, you can see that, okay, the direction is towards IOC, and then at the end of the case. Then, okay, of course, there are disputes between, okay, the jurisdictions of OCM as well as what we call local jurisdictions under the Office of Sports Commissioners. Then I believe that, okay, Tuan Shapawi is here, okay, able to illustrate more with regard to the to clarify the conflict of jurisdiction itself.
Ladies and gentlemen, we have just enough time for just one more question. Sorry, I believe the gentleman at the center of the earlier question.
I'm Brian from Nation Golf, and I want to commend Datuk Sundra's new initiatives in moving towards enhancing the area of arbitration in respect of sports disputes. But I suppose I think that development will take time and as it grows. But I think more importantly, we need very serious structural changes. We have MSN on one end, we have KBS on one end, we have NSA on one end, the National Sports Associations, then we have OCM. 4 stakeholders, all focusing on developing sports. The Sports Development Act itself, if you do care to go through the various provisions, we've got many provisions empowering the minister to make the relevant regulations. Sadly, there's hardly none, except for perhaps 3 regulations. Now, this has caused many challenges, many difficulties for all sports associations. Then I think, frankly, you need to have structural changes within OCM itself. What role does OCM take? Does it take a role to intervene, to make decisions without fear or favor, or does it just remain as it is? I'm speaking with experience in our challenges insofar as resolving issues. Then you have constitutions, national sports associations with their own constitutions. Are they experienced to oversee disputes within their bodies? And this is where the KLRCA can play a huge role in training officials within the respective sports associations to deal with it, because I think at the end of the day there must be an attempt to resolve all issues within your own little backyard as opposed to moving out from there, because the best people to understand your issues are yourselves, all right? And if you're trained to deal with these issues and you will get it resolved quickly so that the athletes growth will not be impeded. And then we have to consider, we have amateurs, we have professionals, and we have the elite category. All of them have got different considerations, different issues and different needs. So it's a huge issue that has to be looked globally. And I think the first place to begin with has to be the Sports Commission. And we have but some 2 years ago, under a special task force set up by the Olympic Council of Malaysia, spent substantive time in trying to amend the various provisions in the Sports Development Act, which is not geared towards developing the sport, as the Act is, Sports Development Act. It doesn't seem so. There are many punitive provisions that impede the growth of sports associations, things like that. So the good place to start with, and with this new initiatives between Dr. Sundra and the Commissioner's Office, I think it's a good place to start as to, and with other stakeholders involved, as to where do we begin? Because the Act is here. You got the National Sports Council of Malaysia Act, you got the Sports Development Act, and for some of you who don't even know, you got the Subang Corporation Act, where we are embroiled in the land issue of Subang Golf Club. So you see, all these are many challenges, and we need to look at acts. They need to be repealed. I think we should repeal these acts. So on that note, Dr. Sundra, thank you very much. I think this law conference is very commendable. I think this is a huge start, Richard and his firm, and I think we should have more of this over the years so that more of us can be engaged, because sports is becoming big business. Thank you.
Thank you very much. Okay, with that, ladies and gentlemen. Before I finalize, one final question. I was so foreign dedicated today as a question.
I came to, hang on. I can actually speak without the mic, right? Yes. Since I came all the way from Singapore and being the sole delegate, I thought I should say something. First of all, I'd like to congratulate Richard, Yip, the firm, and everyone involved. When I first received the invitation, I actually said that I thought it's a very bold, enterprising, dynamic move, and I think they deserve an applause. A bit about myself. I'm a lawyer in private practice. I'm a mediator as well. So you spoke about something which is close to my heart. I'm also involved in sports. I sit in the advisory board of anti-doping in Singapore, and I also sit in the Player Status Committee as well as the Appeals Committee, the Football Association in Singapore. So one of the things which I have been thinking about is it frustrates me that there's not enough scope for mediation in sports. For example, if you have a dispute between, say, an association or a club with an athlete, that can be mediated. But if you have someone committing an anti-doping kind of violation or something disciplinary in nature, there doesn't seem to be that much scope in mediation. So my question to you, Datuk, where do you see mediation coming in? And I do believe that mediation is coming in a big way within this region. What sort of role do you see mediation in sports? Thanks.
I think sports, I believe in an escalated dispute resolution procedure, that it has to start with something that is soft in nature. Mediation is very soft in nature. It is trying to get somebody to actually agree. So let's say if it's a doping issue, if the person says, I'm going to stand for strict legal rights, then it has to be an investigation, it has to be a disciplinary procedure, and it has to be, even let's say if he says no, then he goes straight for arbitration, or he may go to court, isn't it? I think that is the, but let us say, the person says that I want to resolve this. And he says, okay, then we talk on this one, without prejudice basis, which is the mediation procedure, and then you admit. And there could be actually even an agreement where he takes actually, accepts the punishment in a voluntary manner, if there is actually evidence to show. So I suspect, it may work. It depends on how it's handled. But I think it must be done in good faith. Once it's done in good faith, then it will work. If it's not done in good faith, I don't think so it's going to work. So I suspect is that we need to look at how other jurisdictions have been handling, let's say, doping issues, disciplinary issues, whether it has been mediated, and then what are the implications of going through such a procedure to the institution itself and to the athlete. So I think, once we examine that, I'm just, these are generic ideas that we are throwing forth. And generic ideas, like all ideas, tend to have limitations when applied to every situation. So when there are special situations, then we have to handle it. Mediation, I think one of the other thing about mediation is a voluntary process. And again, unless you make mediation a condition precedent to the next step, then you must go through this mediation procedure before you go to the next step. Again, that where it could come in. People may bypass the mediation process, but if you do not make it a condition precedent, people always bypass it. Because they say, I don't want to do something that is voluntary, why should I want to go to the next step. People normally very angry. Anger is a very useful tool to escalate matters. I noticed that, I know. But if you actually have a procedure that actually arrests the anger and gives it a way to resolve, it normally solves it.
Thank you, Datuk. I do apologize, ladies and gentlemen, we have run out of time. In particular to the gentleman in the second row, perhaps you could approach our panel speakers during the upcoming coffee break and address your question to them directly. With that, ladies and gentlemen, please let's give another big round of applause to our speakers. Jady, Ahmad, Shapawi, and Professor Datuk Sundra. If I could invite the speakers to just remain on stage for just a short while, we have a souvenir giving presentation. I'll hand over proceedings back to our MC. Thank you very much, ladies and gentlemen.